we did have a interim committee that made some suggestions on the sandbox bill from last year, and I asked Mike to go ahead and go through that with us. It is in the F drive. It was on the same file that the foreign trade was on. So if you want to pull that up, you can, but Mike will go ahead and go through it real quick.
Thank you, Chairman. Mike Ditch, Legislative Research. Regarding regulatory sandboxes, the interim committee recommended 3 things. The first one being a formal opinion on the constitutionality of regulatory sandboxes in the state of Kansas be requested of the Attorney General. 2, that any regulatory sandbox program adopted in Kansas be generally applicable and not limited only to businesses within a particular industry. And 3, that any legislation enacting a regulatory sandbox program provide for the administering agency to consult with relevant experts while considering applicants to the program. Committee also suggested proposed legislation, and that includes the committee recommending the 2025 legislature pursue legislation to implement a regulatory sandbox program in Kansas, incorporating the relevant recommendations above.
All right, so we'll keep that in mind as we go through this bill, and we're going to go ahead and open the hearing on HB 2291 and get a description of what the bill does from the reviser. Charles Reimer, thanks.
Thank you, Chairman, members of the committee. House Bill 2291 does establish a general regulatory sandbox program for the purpose of waiving or suspending administrative rules and regulations for program participants in an endeavor to offer and make innovative offerings available in Kansas and support innovative business creation. The first section has some definitions. I direct the committee's attention to the definition of agency. It's fairly broad, however, it does exempt the judicial and legislative branches. Section 2 establishes the Office of the Regulatory Relief Division within the Office of the Attorney General. The Attorney General is to maintain the principal office for the division, appoint employees and agents as necessary, prescribe their duties, establish their compensation, subject to appropriations. And that division, the Regulatory Relief Division, is headed by a director who is appointed by the Attorney General. And the director reports to the Attorney General and only appoints staff subject to the approval of the Attorney General. The Regulatory Relief Division itself is tasked with administering the provisions of this act and basically the general regulatory sandbox program. It has some broader duties with respect to just improving the regulatory climate in Kansas for business, including reviewing state laws and rules and regulations that would inhibit the creation of business, provide recommendations to the governor and the legislature on amending or repealing such state laws or rules and regulations, and also creating a framework for analyzing the risk to consumers related to lessening of regulations in general. It can also propose reciprocity agreements with other states that would involve a similar general regulatory sandbox program. And it is granted rule and regulation authority to establish and administer the program. The bill also establishes a general regulatory sandbox program advisory committee. This committee is established for the purpose of assisting the director in reviewing applications for the sandbox program. It is comprised of 11 members, 6 appointed by the director to represent the business community, 3 appointed by the director to represent state agencies, the regulatory agencies involved, 1 member of the Senate appointed by the President of the Senate, and 1 member of the House appointed by the Speaker of the House. The director is the appointing authority for a chairperson of that committee. The advisory committee, as I mentioned, their purpose is to advise and make recommendations to the Regulatory Relief Division with respect to applications. The advisory committee does have authority to recess for a closed meeting when it's looking at those applications. Section 3, there's also a provision in Section 2 that provides the director is to report to the legislature and some items that are to be included in that report, and that report is made to the Senate and House Commerce Committees and also the Joint Committee on Administrative Rules and Regulations. Section 3 on page 3 of the bill provides for the establishment of the General Regulatory Sandbox Program. A couple of items to note there. One is that the Regulatory Relief Division can actually provide a consultation to an applicant before the submission of an official application, and also the division can assist an applicant in preparing an application for submission. The application, there's a number of requirements that are laid out on page 4 of the bill. The applicant has to confirm that the applicant is subject to the jurisdiction of Kansas, confirm that they have established a physical or virtual location in the state from where the demonstration of the innovative offering is going to be developed and performed, and where all required records, documents, and data will be maintained. So records, documents, and data are to be maintained in the state. The applicant is to disclose criminal convictions. Also, a description of the innovative offering is to be included, how the offering is subject to regulatory requirements, each rule and regulation that the applicant wants to have waived, how the offering would benefit consumers, any risks to consumers, how the offering is different from other offerings available in the state, and how participating in the program would enable a successful demonstration of the offering by the business. And finally, a description of the proposed plan. The applicant also has to recognize that they are going to be subject to all laws and rules and regulations pertaining to their offering after the conclusion of the demonstration, and they have to provide a description of how they are going to end the demonstration and protect consumers if the demonstration does not succeed, if it fails. There is an application fee not to exceed $250. The application, any related information is confidential and privileged, with the exception that the information can be provided to an expert that the division contracts with for specific services with respect to reviewing the application and records. After the application is filed, there is a process that occurs, and first the Regulatory Relief Office consults with each applicable agency to determine if more information is required, and if so, seeks that information from the applicant. The Regulatory Relief Division has 5 business days after a complete application is received to review it, and I'll then refer it to each applicable agency, each applicable regulatory agency. The regulatory agency has 30 days to review the application and provide a written report to the director. There is a provision for an automatic 5-day extension upon request. The report is to include a number of items. First of all, describe any identifiable, likely, and significant harm to consumers, and harm would include health, safety, or financial harm. Make a recommendation to the division, and if the regulatory agency recommends that an application be denied, then include reasons for that recommendation, including why there would be a significant harm to the health, safety, or financial well-being of consumers or the public, and the likelihood of such harm occurring. The regulatory agency can also recommend less restrictive means as opposed to just a waiver of the regulation for the program. And if the agency fails to deliver the written report, then the director shall assume that the applicable agency does not object to the application. There are a couple of provisions on the bottom of page 6 that provide for a rejection by an agency and a final rejection. The director cannot approve an application if the agency rejects it for the reasons listed on the bottom of page 6. One of those is if the applicable agency determines that the offering fails to comply with federal law, federal regulations, or any state regulations that were previously approved by a federal agency. The second reason that an agency can reject an application, finally, is that the application would create a substantial risk of harm to the health or safety of the public or create unreasonable expenses for taxpayers in the state. Once the director receives a written application, the director provides it to the advisory committee, and the advisory committee reviews it and provides the advisory committee's recommendation to the director. In reviewing an application, and the regulatory relief division also consults with each applicable agency. So it gets the division obtains the input from the advisory committee and also from each agency, that regulatory agency applicable to the application. There is a provision that I would point out there in the middle of page 7. If a competitor to an applicant is or has been a regulatory relief sandbox program participant, the division and each agency is to weigh such competitor's participation as a factor in favor of allowing the applicant to also become a sandbox participant. There are a number of items that the division is to consider when looking at an application. If it will adequately protect consumers, the risk of harm to consumers, if that's outweighed by the potential benefits to consumers. Consider certain rules and regulations that should not be waived, even if it's approved. And then if the division approves an agreement, then there's an agreement that is entered into, and specific waived are to be listed in that agreement. There is a prohibition upon the director of entering into any written agreement that would waive or suspend a tax, fee, or charge under Chapter 79 of our law. The director may deny an application for any reason. However, the director is to provide the applicant a written description of the reasons. And the denial of an application is not subject to the Administrative Procedure Act or Kansas Judicial Review Act. There are a couple of reasons why, while there is a specific provision that the director must deny an application if there's been criminal history of the applicant. That's in the middle there of page 8. When an applicant is approved, the director may provide notice of the approval to competitors and to the public. Section 4 in the middle of page 8 sort of describes the program. If approved, the participant has 12 months to demonstrate their offering. There are some limitations to the offering. Each consumer is to be a resident of Kansas. No rule or regulation is to be waived or suspended if it would prevent a consumer from seeking restitution in the event that the consumer is harmed. If a sandbox participant has a license in another jurisdiction, the applicant is not to be, the participant is not to be restricted from acting in accordance with that license. And the participant is deemed to possess an appropriate license or under authorization under the laws of Kansas for purposes of any provision of federal law requiring licensure. There are one of the benefits of participating in the sandbox program is suspension of criminal and regulatory liability during that period. So that's at the bottom of page 8 and the top of page 9. A sandbox participant is not subject to enforcement of rules and regulations during the period that are identified in the written agreement, and not subject to charges filed pertaining to rules and regulations identified in the written agreement that for any act or omission during the demonstration period. And an agency is not to file any punitive action against a sandbox participant for violations of rules and regulations that are identified in that agreement and that occur during the demonstration period. However, with those exceptions, a sandbox participant does not have immunity related to any criminal offense committed during the participation period. Section 5 pertains to certain disclosures that a sandbox participant must make to the consumer. Those are listed on the bottom of page 9 and the top of page 10. Section 6, page 10, provides some procedures that must be followed before the end of the 12-month program demonstration period, including notifications to the division. And there is an opportunity for the program participant to seek an extension. There's a report that must be provided. Section 7 pertains to the retention of records. It requires a program participant to retain records, documents, and data produced in the ordinary course of business regarding an offering. And there are provisions in there that deal with, in the event a participant ceases to provide the offering and what information has to be provided to the division, including any incidents of harm to consumers that must be provided. Page 12, provisions pertaining to when the division can remove a sandbox participant, and Section 8 on the bottom of page 12 is just a conforming amendment to the Open Meetings Act that allows the Sandbox Program Advisory Committee to discuss applications in a closed meeting. And that is what the bill does.
Thanks for the detailed explanation. So as you can see, committee, this is a simple bill. I'm hoping that some of these proponents can help explain exactly what the sandboxes do and are supposed to do. Are there questions for the reviser as far as the bill? Representative Hsu.
Thank you, Mr. Chair. I have a couple, if that's okay. So my understanding is this is for innovative offerings. Is there a definition of innovative offering in the bill?
No.
Okay, and then kind of as a follow-up, there's kind of a competitor provision on page 4 or 5, I think. Doesn't the fact that there is a competitor automatically mean that it is no longer an innovative offering?
So in response to that, since there's no definition of innovative offering, I guess that is to the discretion of the committee and the division. And, they would be the entities that would consider that.
Okay. And then 2 more quick ones, sorry, Mr. Chair. On page 4, you say like there's in the application, they have to determine if it's if they're in Kansas, either physical or by virtual location. What do we know what virtual location means?
There's no definition in the bill for virtual location.
Okay. And then final question, if just on the off chance, if a consumer is harmed directly as a result of being as a part of this program, as one of the regulations eased, would that consumer have any recourse at all?
So there is a provision in the bill that I mentioned that rule or regulation is not to be waived if it would prohibit restitution to a consumer. So, you know, there is that provision.
All right, so as far as a competitor goes, if more than one company wants to get into that vertical, the new innovative widget or whatever it may be, they'd be able to do it. So it's not like you're filing for a patent and no one else can do this. It'd be anybody that wanted to do it would have to file and be accepted. Representative Osman.
Thank you, Mr. Chair. So the interim committee made a recommendation about the constitutionality and asked the AG to formalize an opinion. Are you aware if the AG has done so?
So I have reviewed recent AG opinions, and I did not see an opinion pertaining to this bill. But it's possible, you know, I missed it, but I did not see one.
Okay, all right, thank you.
Any further questions? All right, seeing none. We'll go ahead and open the proponents, and we will start with Tanner Temple with AFP. Welcome back to committee.
Test. All right, awesome. Thank you, Mr. Chairman and members of the committee. Again, my name is Tanner Temple. I'm the Deputy State Director for Americans for Prosperity. Appreciate the time to speak on HB 2291, which creates a sandbox program that temporarily waives specific regulations for businesses to test innovations. The term regulatory sandbox actually comes from a legal concept stemming from the United Kingdom's Financial Authority's November 2015 report, where they outlined a regulatory sandbox as a safe space in which businesses can test innovative products, services, and business models. The Kansas Administrative Regulatory Code contains 3.3 million words that businesses must use to assess restrictions on their businesses. A substantial amount of those regulatory restrictions concentrated in manufacturing and professional business services. Regulations interfere with market competition and can become a startup barrier if left unchecked. A more extensive and older firms don't have to compete and innovate, keeping prices high and slowing job growth. Conversely, the more startups, the more people are encouraged to go into business themselves and the more jobs are created. However, I do want to point out, it's important to note that this does not mean sandboxes are a free-for-all. This bill is a growing compromise that allows innovation but maintains consumer health and safety. Businesses can test products, services, business models, and delivery without immediately incurring all the normal regulatory consequences of engaging in the activity. This bill is a good start, but we also see the opportunity for changes further enhance the effectiveness of the regulatory sandbox. A few examples: reduce the 4-year advisory committee to 9 members by reducing the number of 4-year appointments by the regulatory relief director, allowing the regulatory relief director the power to temporarily appoint up to 3 additional members to the advisory committee, allow the advisory committee to override any denial of a sandbox applicant with a 2/3 majority vote of members, allow the regulatory relief office to approve a sandbox application even if an agency denies or rejects such an application, expand the sandbox demonstration period to 24 months instead of 12. So we would allow sandbox participants to apply for additional extensions up to the cumulative maximum of 7 years, including the original 24-month period. I also want to point out we've seen this work overseas. When Notre Dame burnt to the ground, they actually used something like a regulatory sandbox to rebuild it in a safe measure, and it saved them a lot of money as they did it. So we've seen it work overseas as well as we look at this. So for those reasons, we urge you to pass this bill, and I would stand for questions.
All right, so those last suggestions that you just made are changes to the bill?
Yes, sir.
I thought you guys wrote this bill, or you helped write this bill.
We did help write this bill, and we had some amendments I think we were proposing there, so I can double check on that for you.
Okay. Representative Penn?
Thank you, Mr. Chairman. Thank you, Tanner, for being here today. You said on one of your suggestions to expand the sandbox demonstration period to 24 months instead of 12. When we introduced the bill, it was at 12 months for the ramp-up period. Can you explain why you might be amenable to changing that out to 24 months?
Yeah, I mean, when you look at 1 year, it's kind of a short period of time. As we expand that out to 24 months, I think that gives the participant some more time to practice, some of the regulatory relief policies in that time frame. So it just gives the participant more time to work on it.
Representative Wassinger.
Thank you, Mr. Chair. Can you give me some examples of how overseas, when they were rebuilding the cathedral, that they used it?
Yeah, you bet. Let me pull this up here. I actually have it written down. Yeah, so in 2019, the structural fire broke out the roof space of Notre Dame in Paris, the medieval Catholic cathedral. Then 1 month after that, the French lawmakers passed a bill that exempted recovery from most regulations. So the cathedral itself was restored in 5 years at roughly 1/10 the estimated cost. So, and if you're more interested on that, I can send you some more of the research on that as well.
Thank you. Thank you, Mr. Chair.
So can you give the committee any other examples of where this would apply? This is always difficult to try to explain to people, and so I'm hoping you can kind of give us some examples of where it would apply.
Yes, sir. So, I mean, as we've established, as you go into the Attorney General's office, they would establish that committee. So a business comes into the committee. So we, as the revisor pointed out, that 11-member committee, they say, well, this regulation is overbearing on my operation. And then once they present that to that committee, they would either approve or deny that application. So the way it's written right now, and to my understanding, it is a wide broad to any business in the state of Kansas that has to be operated in the state of Kansas.
But no specific, can you name an example of where it would be applied? I mean, I understand how it works, but
yeah,
what would be an example?
Let's say somebody in construction comes to the committee and they have something, a regulatory policy. I can't think of one specifically at the top of my head, but something in that realm. They come to the committee that's overbearing, that does not affect someone in health and safety. They could present that to that committee, and then they could either apply or deny that recommendation from that business specifically.
Okay, Representative Williams, thanks.
Thank you, Mr. Chair. So one of my concerns with this is that it's, according to the fiscal note, adding, I believe, 6 FTEs, plus you have a board of 11 members or maybe 9 members.
Yeah.
And then the time it might take to have those board members hear an application and then determine whether or not they agree or not with the application, that it's an innovative offering. My question is, do you have any other instances in other states or countries, since it started in UK, where we could actually reduce the number of regulatory touches on this in order to get the same objective?
Yeah, I mean, Utah implements this right now, and I believe some of the other proponents that will speak on that here shortly. I mean, he's up in Utah as well, so he'll be on here shortly. He probably can answer that question better than I can on his state up there. But we have seen this implemented in Arizona and Utah.
Okay, well, I'm not sure if that answers my question, but a good point that someone else might be able to do that better. But it just seems like if we have, back to Representative Shu's comment, we actually have some definitions, then we wouldn't necessarily need all of this giant framework. We could actually do the same thing and give the authority to a lesser number, someone in the Attorney General's office. I guess my last question is, does the Attorney General already have rules and regulatory authority? Okay, they do have rules. Okay, my partner here just said that they do, or my colleague. If that's the case, can they not go ahead and put those rules and regulations in place? We create a smaller division, cut down on the cost, and expedite the process and not have the commission. Bottom line, is there potentially an argument to be made that a commission would not be necessary if we had the appropriate regulatory rules and regs so that a decision can be made whether or not, for example, sugaring, is that an innovative offering, and should we curtail cosmetology requirements? I'm just trying to think, this is a whole lot of costs for a small number of returns.
Yeah, I mean, I think there's potential for that. I mean, when we look at this bill and when we look at the committee, it has people from, some of the members, as the bill states. You have people from the business community. You have appointed people from other regulatory industries. You have people appointed from the House and the Senate. So I think it brings their voice to that. I think that was kind of the overlying goal. I don't know if that exactly answers your questions directly, but, I think that was the main goal for them to have a place they can explore some of these, really red tape policies that hold them up in the business world.
Any further questions for the conferee? All right, seeing none. Thank you.
Thank you, sir.
Next up, we'll have Eric Stafford. Are you presenting orally or written?
Thank you, Mr. Chairman. Good afternoon. And good afternoon, committee members. Eric Stafford with the Kansas Chamber of Commerce. I'm here today in support of House Bill 2291. We spoke in support of a bill last year. Also submitted testimony on the interim committee on the subject of regulatory sandboxes. Appreciate the work of Tanner and Elizabeth, and as they've been working to get Kansas on the map as a regulatory sandbox state. Really, it's just to streamline regulations in areas of innovation. You've heard some examples that we've seen and talked about before: the insurance industry, financial tech, the legal community actually has utilized regulatory sandboxes as well. So it's really any industry. Never mind. I was going to bring up an example from Utah that I've shared in the past, but I won't. I get made fun of that from the chairman. But really any industry that runs into a problematic regulation, that the benefit of a business being able to apply and get relief temporarily, either a 12 or 24-month window is typically how it's structured, but those regulations could be suspended. We saw regulations suspended during COVID to allow restaurants to be able to have customers take alcoholic drinks home with them, and then that became permanent law the following year after seeing that everything worked just fine through COVID. So I think really at the end of the day, the sky's the limit, but some of the provisions that are in here are ultimately added as protections to allow, again, the public safety, health and welfare. You have to ensure that you don't jeopardize public safety. And I think to Representative Hsu's comments about the competitor aspect, making sure that one person doesn't get an advantage by being approved, but somebody who might be in the same industry that might not be as quick to get their similar product set up is left behind and still gets stuck behind barriers of regulation. I think that's probably a type of circumstance where it could be more applicable. To Representative Williams' questions about allowing, coming up with a different way that doesn't get so layered, so to speak, in terms of just giving the AG direct authority. We're all for making this the best way, make this work the best way possible. So however that looks, if you guys have ideas on how to make the wheel smoother so it goes faster, then I think all proponents would be open to how that would look. So happy to answer any questions, Mr. Chairman, but I appreciate the opportunity to be here today.
Okay, we'll open questions. Representative Wassinger.
Thank you, Mr. Chair. All right, I talked to a young man who wanted to start a trucking company, but the regulations and everything he had to do was so onerous, he was having a hard time. Mm-hmm. So would that be used in a regulatory sandbox or in another? Well, it's innovative for him. Can we do that for others? I mean, can we expand the regulatory sandbox? Because it seems to me to get people to start into business, usually they fail within the first year. So if they have an opportunity to not have to spend quite as much and then limit it for a year, so then maybe the second year they can get into it. I just wonder if we're keeping it too closed up.
Yeah, good question. And Mr. Chairman, trucking would be a tough example because they're federally regulated as well. So we're only discussing state regulations. But if you recall, Utah, during the interim committee, talked about some college students who basically came up with an Uber-type company for tow trucks. So they did have, and I believe that was a company that was approved by the state of Utah. So there are some examples that are out there, but you have to look at what you're actually waiving. I mean, you can't waive federal DOT regulations that, I mean, trucking is a very regulated industry, as it should be. It's, it's interstate commerce, and there's a lot that goes into it. Yeah, so it depends on the industry.
Thank you. Thank you, Mr. Chair.
Representative Penn.
Thank you, Mr. Chairman. Thank you, Eric, for being here with your testimony here today. Just want to talk about the regulatory landscape inside of Kansas, because while we were on the campaign trail, we talked to a number of our constituents as well as businesses, and they brought up some of the biggest inhibitors that they had to having profitable businesses, providing for their families, is trying to navigate the regulatory landscape inside of Kansas. Can you speak on that? I don't know, from the Chamber's perspective, what does that particular hurdle look like? Would this be an effective tool to identify those regulations and not cede the authority of the legislature in rescinding said regulations, because a few of us sit on joint committee on administrative rules and regulations, and I'm sure that all of you have watched that riveting television show whenever we're in committee. And you see how combat ineffective is using it mildly, that it can be to get after how to help out Kansas businesses and constituents. Do you think this would be an effective tool to lessen the regulatory burden here in the state of Kansas for businesses, sir?
Yes, and a couple points I would make. First one, it would be an effective tool. Again, we're talking temporarily waiving to allow those to be updated or modernized, or let the legislature act to clean up statute where it might be a little bit vague. Two, generally, and this was a few years ago, I don't know where we stand today. I mean, the Cato Institute had us, I think, #1 in the country for our regulatory climate. I think we're definitely top 3 still, but there's been some steps taken from the legislature on the regulatory front in recent years with the REINS Act, most recently last year. Again, talking about the regulatory sandbox, I think that this is, it's definitely a new concept, but states are latching onto it, and it appears to be, from the conversations we've had with them, having good success. Utah being the first to take a full universal approach. But yeah, we hear the same thing from our members. Regulations, some of them might be federal, some of them are state, that kind of get in the way and are problematic. That it's how the agencies interpret the statute that you guys pass, and say the agency can promulgate rules and regulations to implement the law, right? And sometimes those go above and beyond what the scope of what you guys intended to do as the legislature. So I think going forward, a good step for you guys, if you are going to give rule and reg authority to state agencies, be prescriptive about what you're giving them rule and reg authority to do. That would be a good upfront approach from the legislature's standpoint, to be clear on what exactly they have rule and reg authority on. We don't see, the first couple weeks of the Trump presidency, we've read a lot about executive orders being signed, some of them repealing what the Biden administration did, some of them new ideas that the Trump administration's doing. Oftentimes those are to repeal efforts that were made through rule and reg authority. And I would stand up here in opposition of either party and granting that much authority. We don't see it much at the state level from the governor's office or the executive branch and at state agencies at the state level, but it happens sometimes where agencies go above and beyond the scope of what was intended. And I think if that's what you want to do, if you feel like that should be the policy, you being the president or the governor of either party, then the legislature should pass it, right? Don't circumvent Congress or state legislature. I strongly believe that executive power should be tightened up a little bit. So a little away from the concept here of regulatory sandboxes, because this isn't, getting rid of them permanently. It's just a temporary waiver to allow that business to be able to operate, but then allow time for the agency and I will say too, agencies have been good to work with. We've run into some times where they've been trying to do some things and we get business and industry input and they say, okay, understand, didn't really think about that, and they'll kind of tweak with the regulations that they're working on. So, agencies they listen, they understand, they don't want to hurt Kansans intentionally, right? It's kind of oftentimes an unintended consequences more than anything.
Representative Osman.
Thank you, Mr. Chair. I have a question not necessarily for you, but honestly a general question for any proponent or opponent of this bill. I'm caught up on the constitutionality of this bill. And it's a question that I asked previously of the reviser, and I'm just struggling with it. This is going to be housed under the Attorney General, who's part of the executive branch. The executive branch deals with enforcement mechanisms, and I realize that in this bill, it talks about enforcement mechanisms of the regulatory body itself, but I would argue that when we're discussing this in a formalized framework like this, we're really talking about selectively deleting portions of the law for selective people. And that falls into the realm of the legislative branch, and so I struggle with the constitutionality. I don't know if you have if you would be able to comment on that, or if there's anybody else that might be able to weigh in on that.
It's a good question, Representative, and I would like to punt, but in spirit of the Super Bowl, I won't. So I think we're not talking about laws, we're talking about regulations, which are from the executive branch. So, but again, it's suspending temporarily those regulations. Obviously, anything can be challenged. I don't know if there anybody else who could speak to that. I don't know if there have been any constitutional challenges to the regulatory sandbox, but I don't think it's wherever it's housed, whether it's its own office under the Department of Commerce or whether it's under the Attorney General's office. I think in Utah it's under the Department of Commerce, is their Office of Regulatory Relief. So I don't think that matters where it goes, but you're not suspending statutes. If there's you guys have dealt with this issue, and this is a hypothetical that I don't think would ever apply under this setting. But since you're familiar with the topic, say there's an unemployment insurance regulation that falls on employers of a specific industry and they apply for the regulatory relief. It's not necessarily saying that they don't have an obligation under law to continue to pay unemployment insurance taxes. And again, this is a stretch, I'm making it up on the fly, but it's the regulation that's problematic for the success of their business that would be temporarily suspended to get rewritten or introduced to have clarifying statute to address it down the road if you guys are currently not in session when the problem arises. That could give that employer the flexibility to be able to go out and produce and do whatever it is that they make or provide the service of. So it's not the statute that's suspended, it's the regulation itself, if that helps clarify. But I'm not an attorney, I don't act to be one, but that is a good, thoughtful question.
All right, seeing no further questions, thank you very much. I think that's all we have for the oral proponents that are here. Is that correct? Anybody else here? All right, we have, I think, 2 virtually, and we'll start with Reese MP. If you could pull him up, please.
Am I coming through okay?
Loud and clear, yes.
Well, Chair Tarwater and members of the committee, thank you for having me back. I apologize to those who have heard this spiel before, but my name is Reese Empey, and I am the Senior Director of State Government Affairs at Libertas Institute, a nonprofit think tank based in Utah. Although we work on a range of issues in Utah, it's my role to work with partners across the country to bring these innovative policies we've helped usher through the Utah State Legislature to other states, and regulatory sandboxes are one of those. But what is a sandbox? A sandbox enables innovators, both big and small, old and new, to work with regulators and legislators in trialing new products, services, and business models, while rules and regulations that may be inapplicable or dated to new ideas are temporarily waived. So let's say I have an excellent idea for drone insurance, because why do I need a standard 6-month premium business model if I only fly the thing a couple times a year? Or maybe I have a creative way to collect payments at my food truck, or I just want to run a food truck. The ideas and opportunities are limitless, all depending on the structure of the particular sandbox. So I'd approach the sandbox, outline my great idea, and highlight the rules and regulations preventing me from launching my product. Upon acceptance into the sandbox, I'd receive a temporary waiver of those rules and regulations, and I'm allowed to offer my product to consumers. And throughout the trial period, which is typically 2 or more years total, depending on the state, I report to the sandbox on what's happening, how many consumers I'm engaged with, is anything going wrong, etc., so that the sandbox can compile a report throughout the various trials in the sandbox and kick recommended reforms or repeals to the applicable agencies and or even the state legislature. This allows the agencies to make informed decisions on reforming, repealing, or even creating smart regulations around new and innovative ideas so that the entities in the sandbox can exit into a newly reformed regulatory environment. Now, I want to mention that consumer protection is built into these sandboxes, an application that will obviously bring harm to consumers or the environment. It'll never make it through the front door. And if a company in the sandbox begins to act in bad faith, the sandbox has the authority to pull that company out. Lastly, these companies can still be held civilly liable for any harm they may cause. So overall, a sandbox invites the business community to the table to highlight troublesome rules and regulations, prove they're not working as intended in a supervised environment, and as a result, the state is better welcoming to the innovations of tomorrow. It is a living, breathing approach to regulatory reform that possesses safeguards to protect consumers and the environment. There are 2 approaches you can take with this. You can target certain industries such as agriculture, insurance, financial technologies or fintech, salmon recovery, which is currently under consideration in Washington state, and even housing, which popped up for the first time this year in the state of Hawaii. And on the other hand, you can pursue a universal sandbox that applies to most industries. A couple of examples closer to home. Next door in Nebraska, they approved an insurance sandbox in 2023, while Missouri went from having no sandboxes to full universal last year, the first state to do so. On top of that, after Missouri approved its universal sandbox, Ohio is preparing to roll out similar legislation this year, while Indiana plans to consider it in 2026. Now, currently, there are only 4 states with universal sandboxes: Arizona, Kentucky, Missouri, and Utah, and then 11 other states running industry-targeted sandboxes, not counting Hawaii and Nevada's sunsetted fintech sandboxes. So as of now, there are only a dozen states that haven't at least considered a sandbox of some kind. Now, out of the 15 states currently running sandboxes, there have been around 30 participants, but keep in mind, many of these sandboxes have passed in the last year or 2 and are still very new and even being implemented. On top of that, many of the sandboxes have taken on kind of an additional role. They have begun to serve as a liaison between businesses and the relevant regulatory agencies, which has allowed many companies in universal and targeted sandboxes to learn they can operate without the sandbox. In other words, rather than just waiving regulations, these sandboxes are also helping companies get on their feet and learn they're legally allowed to operate, which doesn't require them to, hire a high caliber lobbyist to help change the rules or an expensive attorney to comb through the state's code and give them an opinion. Both alternatives costing a lot of money, especially for smaller businesses. And from what we're hearing, businesses really like having this type of liaison available to them, and they feel a lot more comfortable when the sandbox is housed outside of any regulatory agency. It's also worth noting that this has largely been a bipartisan issue across the country. Last year in Missouri, the Universal Sandbox received bipartisan support as it moved through the process. Nebraska's insurance sandbox was carried across the finish line by Senator Anna Wishart, a Democrat, after initially introducing a universal sandbox bill in 2022, and states such as Vermont host an insurance sandbox, while, as I said earlier, Hawaii is considering a housing sandbox. With momentum growing for this smart regulatory reform at the state level, a bipartisan group in Congress has begun introducing sandbox legislation for the federal level. To date, 12 different sandbox bills targeting everything from fintech to AI and banking, and even universal, have been introduced. Now, there's also the opportunity for reciprocity agreements with other sandbox states and even cooperation with federal sandboxes should they be approved. Let's say an innovative company enters Kansas's sandbox and they want to scale up. If Kansas has an agreement with a state like Arizona or even North Carolina, which hosts a fintech and insurance sandbox, this company in Kansas's sandbox instantly has a foot in the door to those additional markets and vice versa. Sandboxes provide opportunities for creative minds to try out their new and innovative ideas while providing regulators and legislators with real examples of regulations not working neatly in today's fast-moving, innovative world. Rather than startups or even existing companies spending thousands of dollars on lawsuits, lawyers, or lobbyists to change the law to accommodate them, which not all of them can afford, this offers a more affordable and transparent avenue to trial their ideas, and we can't begin to imagine the potential life-changing or just plain cool products and services that may come as a result of this new flexible regulatory framework. Now, to kind of circle back to some questions that were asked earlier, in terms of the advisory committee established in the sandbox, I'm not finding immediately in Kansas's bill, but in Utah, it's my understanding that the advisory committee members are not paid for their time, but they do receive a per diem. I can let Director Ishihara, Utah Sandbox Director, elaborate on that or correct it if needed, as well as provide insights into how much staff it actually takes to run this in Utah, as well as how much of their time and financial resources are dedicated to this program. Regarding the constitutionality, to my knowledge, none of the 15 states currently running sandboxes have faced constitutional issues. The waivers are temporary, and it comes down to the regulatory agencies and in some states, the state legislature to make the permanent reforms or even repeal. Utah, for example, can temporarily waive statutes and administrative rules. We haven't run into a constitutional issue in Utah. But then you have states like Missouri, and off the top of my head, I believe Kentucky, it only applies to administrative rules. Thank you so much for your time, and I'm happy to take any questions.
Thanks, Reese, and thanks for answering some of those questions. I think what Representative Williams was talking about was the 6 full-time positions that the Attorney General is saying that they will need to open this department, and I'm hoping the gentleman from Utah will be able to kind of explain how theirs is working. Any questions here? Representative Williams? She's going to hold her question. Any other questions? Representative Clayton.
That's okay. Thank you, Mr. Chair. Thank you for your testimony today. You mentioned the Missouri regulatory sandbox bill and how it had bipartisan support. Could I have a bill number for that, please? I know it was from last year, but I want to look it up.
Yes, I believe I have it hyperlinked in the testimony I submitted. It is SB 894, sponsored by Senator Travis Fitzwater.
Thank you. And do you have, is that bill similar to ours in any way? I mean, just because I think most of Kansas's population kind of sits on the state line. So obviously looking at Missouri legislation, that's the one that I'm going to be looking at the most closely to see the way that it works with the competition between the Kansas side and the Missouri side of the Kansas City area. So are you seeing a lot of similarities in their legislation and ours?
Absolutely, and some of the changes that AFP recommended brings it more in line with how Missouri's is structured.
Thank you.
All right, I'm not seeing any other questions for you, sir. Thanks so much for taking the time again today to enlighten the committee. We're going to move on to Dane Ishihara.
Thank you, Chair and committee members. I don't have a pre-planned presentation. I'm just here to answer any questions you may have on the operations of a regulatory sandbox.
Okay, so you've heard some of these questions, and I'll turn it over to Representative Williams that has one for you.
Thank you, Mr. Chair. So we have the Utah representative here, is that right? All right, great. So can you tell us where we can find the list of companies that were approved for regulatory waivers since 2018?
Yes, we've submitted annual reports each year. I can send those over to Reese and his team to forward. We only have the most recent year's annual report on our website, and that wouldn't have the historic information, but I can definitely share that.
Do you have off the top of your head how many that would be annually?
So there's only been two participants that have made it through the entire process, and that was a towing dispatch company that I think was mentioned earlier, and then a title insurance company mentioned earlier. And as kind of Reese highlighted, our office has turned more into almost like a business ombudsman office, where we have a lot of contact with businesses that are just having issues going through kind of the regulatory process. And then we connect them with the right state agency and help them navigate that process. And we have the formal process outlined in the statute, but a lot of the times, and what we found is we pre-screen applications, and we can find other resources and other avenues for businesses to kind of move through the process. And then the applicable agency will come back and say they don't need to participate in the sandbox. Here's what we need them to do. In Utah, we're fintech regulatory light, and so we have a lot of fintech businesses contact us, but they don't need the regulatory sandbox in Utah.
So, sir, for clarification, since 2018, you've had 2 participants that have gone through the entire process and actually received the waivers. Is that correct?
From 2021, when we had the industry agnostics.
2021. Okay. And just on a quick Google search, I saw quite a few websites in Utah that had non-traditional legal services for sandboxes. So in general, would you think that, I mean, it's a hard question to ask. It's so hypothetical since you only have 2 participants that actually went through the whole process. How many would be more service industry, such as legal non-traditional services, rather than those that are actually more like innovative product creation?
That's the legal sandbox that is administered by the state bar in Utah, so it's a separate sandbox. And I know they've had a few dozen participants through their process, but that goes through a different organization.
Thank you, sir. And my final question is how many FTEs does Utah have to maintain the program and to be looking for regulatory relief, let's say?
So it's myself as the director of the Utah Office of Regulatory Relief, and then I have 1 policy analyst that assists me.
So 2.
And you could probably function with 1 full-time FTE, honestly.
All right. Thank you, sir.
Thank you.
All right, any further questions for the director? Representative Wassinger.
Thank you, Mr. Chair. Did I hear you say that a title company got into the regulatory sandbox? What was that for? I'm a title company owner, so just
So it was kind of a unique statute in Utah where it was they're trying to vertically integrate their business model, and it was the percentage of their real estate company that they could refer to their title insurance company. And so it was a 30% requirement. They couldn't go above that. No one really had a reason why they just picked 30%. So they were able to participate in the sandbox for a year. And then prior to the next year, the statute, I believe, was amended.
All right. Thank you very much. Thank you, Mr. Chair.
So in addition to approving companies for the sandboxes, do you also kind of comb through the regulations and suggest some that are overbearing and could be changed? And have you had success with that?
So we're just going through, in 2024, there was a legislative change with our office where we're required to deep dive at least 2 industries per year. We're just starting that from last year, so I don't have feedback on how that's going to go, but we are charged with like deep diving at least 2 industries. And in Utah, we have targeted industries, and we're housed under the Governor's Office of Economic Opportunity. And so we pick either a targeted industry or our advisory committee can recommend an industry to deep dive.
All right, sir, I'm not seeing any further questions for you. Thank you very much for being here.
Sorry, Mr. Chair, I forgot to bring up one other additional thing. An internal policy that we did create is we do not want to circumvent the legislative process. So if a very specific topic has been broached by the legislature the prior year or maybe the prior 2 years, we're not going to review those applications because the legislature made their determination. I think that kind of ties into the constitutionality. We haven't ran into that in Utah, but we don't want to circumvent the legislative process.
Okay, thanks for that, Ad.
Yeah, thank you.
All right, so I am not showing any further proponents, either virtual or in the room, so we'll close opponents. Are there any, proponents, are there any opponents that are here today? All right, seeing none, we'll close that. Any neutral testimony? We're seeing none, so we will close the hearing on HB 2291. We will now look at 2304, and we'll get a brief description from the reviser.
Thank you, Chairman, members of the committee. HB 2304 shifts gears to the Department of Commerce's economic database. So this bill would amend both of the statutes that set up and pertain to that database for economic development programs. Section 1 is make some changes to the definition section. You'll see that the definition of economic development incentive program is amended by adding local government-based economic development programs, and there's a list of those programs on page 2, first part of the page. The bill also adds a definition of local government to mean any city, county, or unified government, or any subdivision, or any instrumentality of a city, county, or unified government established for the purpose of economic development, and that's funded in whole or in part by that local government. The bill adds some language to the definition of recipient. It includes within that definition that a recipient is identified by the business name filed with the Secretary of State, and also if the recipient is an enterprise created primarily for the purpose of the economic development project, then recipient includes the enterprise or enterprises, partners, or principals that own or individually or with other enterprises have a controlling interest in the recipient. The bill adds a definition for searchable website or web page to mean a website or web page that allows the public to search and aggregate information that's required by these two sections, including requirements that the website or web page offer users the ability to search and display data, at least by economic development incentive program recipient and the location of the project by county. Section 2 makes some amendments to the requirements with respect to the information and the database. The first part of those changes on the bottom of page 3 is that the database is to be a searchable website or web page. It details requirements for the database that are more comprehensive than currently in law. It requires that it's comprehensive of all information required by the section. It must permit searches by the program, by the county, by recipient. It must permit a search of independent categories, separately identified categories, again by the program, county, and recipient name. And a search result is specified to include all information required by the section. It's to be in one printable or downloadable report. And in addition, there's a requirement that the website be configured to provide a summary report when requested by the user. And that summary report is to provide total incentives awarded to the recipient and total incentives that have been provided to the recipient, and again, provided by program, by county, and recipient name. Local governments, the next two provisions there on page 4, B1 and B2, require provision of information with respect to local government programs. And B1 on the middle of page 4 requires local governments to provide prior to July 1, 2025, all available and reasonable obtainable information for their local economic development programs that provide more than $50,000 in value in annual incentives. On and after July 1, 2025, that information is a condition of the local government providing any incentive to a recipient. And again, there's a line there for programs more than $50,000 in value in annual incentives. And there's a requirement that that information be provided within 30 days of the execution of the agreement between the local government and the recipient to the Secretary of Commerce. Paragraph 2 there provides, with respect to a recipient of more than $50,000 in value of annual incentives from a local economic development incentive program. Again, there's a condition of the award of the incentive. The recipient has to agree to provide that information to the Secretary of Commerce. So those provisions require the information to be provided as a condition of any local incentive program after July 1st, 2025. The final item in this bill is, if you turn to page 6, this amends current law that requires a report by the Secretary regarding certain information that the Secretary has chosen not to disclose. And one of the exceptions to the requirement of information on the database is that if the Secretary determines that that information might inhibit a program or somehow derail an economic development program, the Secretary does not need to disclose that. However, current law requires the Secretary to report that to the Commerce Committees. And this provision adds a date when that report has to be made in the middle of the page there on page 6. And that is what the bill does. If enacted, it would become effective on July 1st, 2025.
Okay, Charles, I've got just an initial question on that. Since it becomes effective July 1st, 2025, there's a section in here that requires the local governments to report this information before July 1st, 2025. Is that, should that be different?
The language actually refers to programs commenced prior to July 1, 2025.
Okay, yeah, I didn't catch that. Thank you. Any questions for the reviser on this? All right, seeing none, thank you very much. And we will open the proponent testimony. This is this law, it initially started, I think, 5 years ago in Commerce Committee for a transparency database, and it's kind of been a work in progress. And the Department of Commerce, I know, has made several updates, recent updates that are welcome, and they're working quite well now. This is more for the local deals, and I will turn it over to Representative Williams here. She's the first proponent, so we'll let her go first. Thanks.
Thank you, Mr. Chair. Would you like me to just stay right here?
That's fine.
Okay. Thank you, committee, for the opportunity to talk about this. Just a little bit of historical context. Yes, it actually was passed in 2019. However, it took 2 years prior of work trying to bring it and prepare it, and it was a bipartisan effort even 7 years ago. So with that, I also want to thank Rachel Willis for providing some information to my office today regarding the amount of expenditures that we in the state of Kansas give out in incentives. And so I do have that. I have not thoroughly reviewed that to see if it's all conclusive. However, if you look at my testimony, there were a few typos. I did update the testimony. I do want us to all to be aware, and I think we are aware, that there are there's over $1 billion annually easily spent in incentives. And most of those can be seen in tax credits, but there are also some sales tax exemptions. And then, of course, you've got the additional compounding effect that occurs at the local level. The problem that we have here in the legislature is when we're trying to look at incentives, then oftentimes we don't know what's happening at the local level. There are tax increment finance districts, there are CID districts, and what happens is one potential recipient may get a couple million at one level, and then they may get an additional millions at another level, and we just can't see that, and therefore we are not making the best decisions. What this bill aims to do is actually clean up some of the good work that Commerce has done. It took a very long time to get us where we are. In fact, in trying to get the website to be functional and to do the things that it was supposed to do, we did request a legislative post audit, and we evaluated the site. And because of that audit, I think it prompted the Department of Commerce to continue their work and improve the site so that it has the majority of things that we're looking for. There seems to be a misunderstanding on some of those things. And one of those things that we don't have from the website really is the totality of the commitment we have made in the investment of incentives. And that's the request that I recently made in appropriations, where it passed almost unanimously in the House Appropriations, which was we will withdraw $1 million of the Department of Commerce's funding until such time that we receive the total amount of incentive investment, which I got today, which again, I need to take a look at. So where does that place us, and why is this so important? There was a legislative post audit back in 2023, I believe, that evaluates some of our biggest economic development incentives. And one of those, for example, is HPIP, high performance incentives, and great program. But this actually provides a 10% tax credit to businesses that have higher than normal rate of wages. And usually that's going to be, I think, predominantly manufacturing, if not exclusively. But what this audit showed is that between the years 2017 and 2020, I believe your testimony that I written says 2018. I went back and it looks like it's 2017. $3 billion worth of incentives were allocated during that time period. That doesn't mean it's claimed, but that's $3 billion that were on the hook. Last week, we heard in this committee, one incentive, one out of all of the incentives on the database, one of those in 10 years will cost us $225 million every single year moving forward. So I think the reality is, as legislators in creating policy, sometimes we just don't understand the impact of what we're doing, and I want that to be as crystal clear as possible. One thing I would know on here, there is some testimony, I'm not sure if it's online only or if it's going to be oral. It looks like it's online only, from Spencer Duncan, and I concur with his thoughts that we cannot have this so difficult for our local entities, our local governments, that they can't provide. It has to be in a form and a manner that they can just provide the information to the Department of Commerce, and it's easy. I absolutely agree with that. I also think that the bill can be revised, so if there are too many local incentives and we don't necessarily need them all, we could condense those. And then the other thing that there's another suggestion that's not in this bill, and that might be that a solution might be to Commerce's concern that this is very, laborious for them to manage, is that there be an administrative cost for every incentive. So for example, if I'm receiving HPIP annually and I'm having to renew it annually, then in order for it to be maintained on the website, I will have a piece of that comes back so that it can be maintained and so that the public can know about it. And I don't know what that dollar amount is, but I would ask the Department of Commerce to consider that. What would be that dollar amount? And then the last thing I'd like to comment about is in the bill, and it's actually on page 4 of the bill, and it's towards the bottom. It's number 2 on the bottom. And in discussions with Rachel, if you go to the website, for HPIP, it does not tell the totality of what it costs. It gives you how much was claimed and how much was available for, I think it's got a couple years on it. It has 20 and 21. So it's not fully updated, and we would like to encourage the Department of Commerce to continue to update it. But the point on that is it does not have the amount that is given or claimed by each company. It only has the amount in totality, and the response back to me is the Department of Revenue will not provide that information. So we have an answer to that in the bill, and that's on page 4. And basically that says that as a condition of receiving an award, whether it's local or state, then you agree to provide all information required by this section so that it may be made public. That does not mean your tax. It doesn't mean your social security number, your tax ID number, nothing like that. But I think it is fair that if you're going to receive incentives that we, as policymakers, local and state, as well as our constituents, understand it. And I said this before, but this is the last comment I'm gonna make, is that this does impact our budget. This year alone, for 2026, this upcoming year, this fiscal year, before we walked into the door, we were already $400 million underwater. That means our expenditures were outpacing our revenues by $400 million. That's for 2026. Then we went into appropriations and we added $267 million on top of that. That's this year for 2026, not this fiscal year, but the next fiscal year. So now we're over $600 million underwater. And so that's because we should never be outpacing or never spending more. So my point on that is that every dollar that we provide incentive may be absolutely great idea, but that's a dollar that we either A, don't give back to our constituents, or B, can't be used to balance our budget. It does have a fiscal impact. We just cannot see it. And I truly believe, as I said last week, that these dollars can also go back into the hands of our constituents, and they will provide the best ROI because it was their earned income. They can invest it, they can spend it, and they can use it to grow their business. So with that, I will stand for questions.
Representative Clayton.
Thank you, Mr. Chair. Representative Williams, I'm just kind of working up some of the history of this. Could you remind me of the bill number from the 2019 bill? The bill number. Yeah.
Actually, I did have that. I saw that today. I did not pull that, but I do have it in a folder. But I think it was 2022. It was in the well, it wasn't 20. I think it was 2022. The bill number may be 2022. I could be completely off, but I saw it today and I just didn't grab it.
Yeah, if you could just email that to me at some point. I just want to, I want to go back and look and, make sure that my members know if we were voting yes or no so that we can have continuity.
The KLRD could do that, or revisers could do that. That'd be easier than me being able to find it.
Okay, we'll work on that for you. Any further questions for Representative Williams on her testimony? All right, thank you. Representative Kessler.
Thank you, Mr. Chair. I can't help but I was kind of looking at HPIP just a little bit. I remember back in 21 that we decoupled HPIP from KIT-KR, and your numbers were actually before that decoupling. I mean, is there any way to find out those numbers since we've decoupled HPIP with KIT-KR?
I think we could, but I also would know that on KIT-KR, those are very small programs, so it probably would be a limited impact.
But before 21, you had to qualify for KIT-KR in order to apply for HPIP. But by separating that out, I figure HPIP might actually even be higher. That's what I'm trying to get at.
And that's an excellent point. And the interesting thing is, numbers, the numbers that I have received from Commerce don't seem to be completely adding up with what legislative post audit. They seem to be a little less. So I did inquire about that. I'm not sure why they would be less, but bottom line is I don't think we have any idea about how much is on the hook compared to how much is claimed annually and how much could be claimed annually. For example, HPIP, that's a 16 years transferability, so.
Right, so we might want to make sure that we get a report on, or the transparency on what is offered rather than claimed, because they're all out there and will be claimed eventually. Like the low-income housing tax credit that we spent $1.5 billion on in 3 years, none of it has been claimed and none of it's showing up in the budget currently, and it's a lot of money. So, any further questions? All right, seeing none. Are there any other proponents for this bill that wish to testify orally? All right, I'm not seeing any, and I'm only seeing 2 neutral written only testimony. Is anyone here as an opponent? All right, seeing none. We will close the hearing. All right, committee, we are out of time for the day, so we won't be working any bills, and we are adjourned until tomorrow.